why there is a necessity of all India bar exam, that is one of the questions which may come in your mind. Does that mean that the university to which your college is affiliated is not competent to award a degree, or whether this is some kind of a situation creating a non-trust on the affiliated colleges, affiliated universities? Let me tell you very frankly, fortunately, your university, your college is doing good. But in the entire country, there are large number of other colleges, other universities who are not able to come up to this level. It was told a few years back by the Honorable Supreme Court of India that the advocates who will be passed out from those colleges and the universities who are unable to maintain their standard will be called as half-baked lawyers. This is not my phraseology. This is a phraseology used by the Honorable Supreme Court of India in a judgment. So now the question is, what will happen to those half-baked lawyers if those lawyers are allowed to practice without having sufficient practical examination or sufficient practical aspects? Now, we are aware that under the scheme of the Advocate Act, the Bar Council of India has formed a legal education committee. That legal education committee is the authority who will lay down the standards with reference to the education. But despite this, the fact remains that for enforcement of those standards, there are different universities who are supposed to insist on compliance of those standards. There were law colleges even in the state of Maharashtra and even in our vicinity who were not having adequate infrastructure, who were not having qualified staff. And let me tell you with a sense of responsibility that as on today in the state of Maharashtra, we are having more than 150 law schools, and most of them are not having qualified staff. What happens what happens if there is no qualified staff? Of course, there will be compromising the standards. The staff includes the teaching and the non-teaching staff. Non-teaching staff one can understand, but in the state of Maharashtra, not only in the state but in the entire country, you will find there is an acute shortage of a qualified teaching staff. Most of the colleges in the country are having problem with reference to the qualified principal of those law schools. Not only this, there is a huge gap between the theory and the practice. What we have been taught in the law school is based on the curriculum which has been fixed by the relevant university. The general standards have been laid down by the Bar Council of India. But the fact remains that for enforcing those standards, there is no sufficient mechanism. You may be aware that some universities started 80-20 pattern, namely 80% marks for the written examination, 20 marks for the internal. Then some universities went ahead and said 30-70, 30% viva voce, etc., internal work, and 70 marks for the written examination. Some universities have gone to the extent of 60-40 pattern. As a result of that, to be very frank, it is difficult to fail in the examination which will be conducted by different colleges and different universities. Having said about this, the Supreme Court of India realized the situation, and therefore there was a Solicitor General by name Gopal Subramaniam who was asked to look into that. There was an order passed by Justice Dalvir Bhandari along with Justice Ganguly in the year 2009, directing the Bar Council of India to form a committee to look into these aspects. That committee submitted the report, and then the Gopal Subramaniam, the then Solicitor General of India, he invited the order of the Supreme Court saying that we will conduct exams. Those are the exams which will be known as All India Bar Exam. I must tell you, there are several issues, like different state bar councils have different roles. There are 19 state bar councils. On the same line, you will find that there are different universities who are having different syllabuses. But the fact remains that so far as the All India Bar is concerned, there has to be a common consensus so far as some kind of an exam is concerned. Now, therefore, you may note down Section 6 of the Advocate Act. I made a reference about that. Section 6 speaks about the duty to enroll the advocate. Let me take all of you to Section 24. Section 24 of the Advocate Act contemplates that person who may be admitted as an advocate. Now, these are the eligibility conditions which have been laid down. I will request all of you to read that. Then comes Section 49, which gives a power to frame the rules. The rule-making power is with the Bar Council of India. And you may note down Section 49, subsection 1, and then small a, small h. So 49(1), small a, small h. I read for all of us the conditions subject to which the advocate shall have the right to practice and the circumstances under which a person shall be deemed to practice as an advocate in a court. So therefore, this is that source of power based on which the Bar Council of India came forward and framed the rules. Bar Council of India is having a power under different provisions to frame different rules, and therefore the entire rules have been divided into different chapters, different parts. So far as today's session is concerned, we are concerned with part 6, and the chapter is chapter 3. Chapter 3 comes after, of course, chapter 1 and 2. Chapter 1 speak about restrictions on the senior advocate. So we will come to know that what are those different points which are covered. So chapter 1 is about restrictions on senior advocate. Chapter 2 is about the standards of professional conduct and ethics. I am sure in your syllabus you must have gone through this subject. And then the chapter 3 comes, which is about the conditions for right to practice. Prior to 2010, there were only 8 rules. Now, after that, 2 more rules have been added. Those rules says, I will read for all of us. No advocate enrolled under Section 24 of the Advocate Act shall be entitled to practice under Chapter 4 of the Advocate Act unless such advocate successfully passes All India Bar Examination conducted by Bar Council of India. It is clarified that the bar examination shall be mandatory for all law students graduated from the academic year 2009-10 onwards and enrolled as an advocate under Section 24 of the Advocates Act 1961. Now, therefore, it is having a prospective implementation. I hope and trust that all those participants who are alumni, they have graduated from the academic year 2009-10 onwards. So therefore, these are the students who are eligible under this scheme. I'm sure these are the students who must have been enrolled under Section 24 and finding their name on the state roll maintained by the State Bar Council. So therefore, they are eligible. Now, please see the wording which is in the negative manner. No advocate enrolled under Section 24 shall be entitled to practice unless such advocate successfully passes All India Bar Examination. So you can come to know that there is a mandate. That mandate is something more important, and if you do not pass that exam, then you will not be allowed to practice. Then comes Rule 10. As I said, there are only 3 rules which have been added. Rule 10. All India Bar Examination shall be conducted by Bar Council of India. Then Sub-Rule 1A says at least twice in the year. Then the Sub-Rule B says the bar examination shall test advocate in such substantive and procedural areas as the Bar Council may determine from time to time. Now, this is one of the deviation. In the syllabus of LLB, you will find that there are different laws which have been prescribed. Some of them will be picked up by the Bar Council. Those will be for testing the substantive and procedural laws. Then sub-rule C, substantive and procedural laws, areas and syllabi shall be published by the Bar Council of India at least 3 months prior to the scheduled date of examination. There are 19 such headings which have been published with reference to the exam. These are available online, but let me tell you, for 17th examination, there are so far 16 examinations have been conducted, so therefore 17. 17th examination, you may note down Constitution, there will be 10 questions, IPC 8, CRPC 10, CPC 10, Evidence Act 8, Alternate Dispute Resolution 4, Family 8, Public International Law 4, Public Interest Litigation 4, Ethics 4, Administrative Law 3, Company 2, Environment Law 2, Cyber Law 2, Labor and Industrial Laws 4, then Torts and Motor Vehicle 5 questions, Taxation 4 questions, Contract, Specific Relief, Transfer of Property, Negotiable Instrument, in all 8 questions, Land Acquisition 2 questions, Intellectual Property 2 questions. For the sake of convenience, I'll read it once again. Constitution 10, IPC 8, CRPC 10, CPC 10, Evidence 8, ADR 4, Family 8, PIL 4, Ethics 4, Administrative Law 3, Company 2, Environment 2, Cyber 2, Labor and Industrial 4, Torts and Motor Vehicle 5, Taxation 4, Contract, Specifically Transfer of Property, Negotiable Instrument 8, Land Acquisition 2, and Transfer of and Intellectual Property 2. This is the syllabus which has been published. Now, the question came that who are going to assess, because these are the professional bodies, the apex body like Bar Council of India. We do not have a body of the experts apart from the educationalists who are spread throughout the country. Apart from that, it is said that the percentage of marks required to pass shall be determined by Bar Council of India. Then it has said that without any limit, you can appear for this exam if you have failed. Then there will be a format of the application will be decided by the Bar Council of India. And after completion of this entire exercise, you will get certificate of practice that has been provided. So therefore, now there is another document. One is Sanad, namely license to practice. And apart from that, certificate of practice is now introduced under this new rules. Now, Section 11, Rule 11 contemplates that within 30 days of declaration of result, certificate of practice shall be issued to those successful candidates. And it will bear the signature of the Bar Council of India chairman. Now, having said about this, my simple appeal to the professors that those who have passed, please make an appeal to them that without fail they should collect certificate of practice. In the state of Maharashtra, we are having around more than 4,000 certificates of practice which have come back to the Bar Council of Maharashtra and Goa because the addresses were not sufficient, addresses were changed, and maybe the persons have refused to accept this. So therefore, there is an appeal to all professors who are attached that in every such endeavor you can make an appeal that this should be collected from the Bar Council. Now, once this exam was made mandatory, again there were debates before different high courts. Petitions were filed challenging the validity of these rules. The contention, the legal contention was this, that Bar Council of India and the Bar Council of Maharashtra and Goa are having certain functions which have been laid down under section 6 and 7. However, after enrollment, how can you introduce a exam? That is an issue. What was the challenge? Challenge was to the rules which are framed by the Bar Council of India in the year 1995, which is known as the training rules. Your professors who are senior enough, they will be able to share those experiences with you. In the year 1995, rules were framed by the Bar Council of India, saying that after enrollment, 1 year, an advocate will have to complete a compulsory training. That compulsory training will be with a senior lawyer. And unfortunate aspect was that most of the lawyers who got enrolled, they just prepared their notes, notebooks, and obtained the signature of different lawyers with whom they were supposed to complete 1 year training. So that was a ground reality, and unfortunately that was challenged in the Supreme Court. And in the case of V. Sudhir, judgment came to be delivered by Justice S.V. Mazumdar along with Justice S.N. Fukan. The judgment is reported in 1999, Volume 3, Supreme Court Cases 176. This is an appeal to read that judgment, V. Sudhir versus Bar Council of India. And these rules of 1995 were struck down, holding that the legislators have made it clear that the role of Bar Council of India ceases as soon as the person is enrolled. You can't enforce some new exams after the advocate is enrolled. And now, therefore, when these rules were challenged before different high court, the matter was carried to the Supreme Court of India. All those matters were clubbed. And in the year 2017, it was realized that there is now need for the purpose of reconsideration of that V. Sudhir judgment. So therefore, now 3 questions were formed, and the matter is now referred to 5 judges constitutional bench. Senior advocate K.K. Venugopal, who is former Attorney General of India, was appointed as an amicus curiae in the same matter, and he has been continuing his noble duty even today. And those recordings of the constitutional bench are available on YouTube even today. So there is an appeal to all my young friends, young Indian legal brains who are on that side of this online webinar, that please visit those YouTube channel live streaming of Supreme Court of India. Last week, the 2nd or 3rd date of hearing was over. As a result of that, now those live streams are available on the YouTube. You may be aware that there are some states like Gujarat state, which is having live streaming of the court hearing. Karnataka, the same thing is happening. So far as the state of Maharashtra is concerned, you can log in online for a virtual court in some honorable benches, before some honorable benches. So these are the different use of the technology which have been propagated by the E-Court Committee of the Supreme Court of India. Having said about this, there is an appeal that Bar Council of India as well as Bar Council of Maharashtra and Goa, they are also having their YouTube channels. The appeal is kindly subscribe though. Not only that, I have also my YouTube channel and I wish to upload this video, of course, with the permission of the authorities, so that even at a subsequent point of time, you can go through these videos. Now, the question was raised before the Bar Council of India that can these students be permitted to have an access to the BARE Act, because large number of students realize that there is a huge gap between the theory and the practice. Therefore, though these are 100 multi answer question or MCQ, multiple option questions, etc., despite that, the students were finding that it is difficult exercise. You will be surprised. I am aware that several lawyers could not pass this exam despite 3 attempts, 4 attempts. That goes to show that perhaps they are afraid of the exam. Perhaps they are afraid of this entire exercise, which is to be done once again after getting a sanat. And perhaps it speaks about the gap between the theory and the practice. So therefore, decision was taken that the Bayer Act, without any short comment, without any digest, should be allowed to be used for this exam. So therefore, don't worry, you will be having a ready reference with you, that is a Bayer Act, which will be available. There is a press release of 23rd of October 2021 to that effect, permitting use of the Bayer Act. Now the question comes, what you are supposed to give at the time of enrollment. At the time of an enrollment, you will have to give an affidavit and an undertaking stating that if you fail to pass this exam, you will not practice before any court of law. This kind of undertaking or affidavit is required to be submitted. I believe you must have done that. If you have not done, then I'm sure you might not have registered with the Bar Council of Maharashtra and Goa, because it is mandatory and this has been done for various years. The initial rules contemplate, 2010 rules contemplate only 3 rules, but the clarification was given by Bar Council of India, saying that unless you pass this exam, you cannot wear band, you cannot wear gown, and you are not allowed to appear in the court of law. But again, there was a public demand, and therefore, on an undertaking, they have been permitted. Now the question came that if somebody fails, then what is to be done? And now Section 30 of the Advocate Act has been given the effect. As a result of that, any advocate practicing in any court of law registered with any state bar council can practice everywhere in India. That means a person from Gujarat, Madhya Pradesh, Goa, or even Jammu and Kashmir, or a Far East, namely Northeast, Manipur, Meghalaya, Tripura, Assam, or even Sikkim, they can practice in any court in India, including the courts where you are practicing or you are going to practice. And now, therefore, one more safeguard came. That safeguard came in the year 2012, that unless you pass this exam, you will not be entitled to transfer your sanat. You are aware that on account of marriage, on account of shifting place of practice and the place of residence, or otherwise voluntarily, there can be transfers. Those transfers were not permitted with effect from 2012, that is 18th of July 2012, unless you pass this exam. Now, having said about this, now the question comes that what will happen to those persons who have appeared for this exam and passed those exams, but tomorrow the Supreme Court of India decides that these rules are ultra virus. What will happen? Then in that eventuality, perhaps the new matter will come, perhaps amendment will be required, perhaps some more measures will be required. But the fact remains that you as a student of law, you should take benefit of this particular examination. And these are the questions which are based on the practical experiences. Therefore, once you pass this, this will also give you a different eyesight as to what will be the practical aspect of our legal education. Now, there are several videos which are uploaded on the YouTube in English and Hindi language by different advocates or different institutes. And those videos are useful for the purpose of how to fill up the application form, which are the books which are useful, how a preparation can be made for these exams. Authentic. Instead of that, you should keep watch on the Bar Council of India YouTube channel as well as Bar Council of Maharashtra and Goa YouTube channel. Having shared this information, now the simple question arises whether these are the sufficient steps for improving the standards of our legal profession. The answer will be no. This is one of the such a step which has been taken. I'm sure this is not sufficient. Much more things will have to be done. In the state of Maharashtra, we have around 240,000 lawyers approximately. And in last 3 years, around more than 30,000 lawyers got enrolled during this COVID batch. This COVID batch is unfortunately known as a batch who have not got enough academic knowledge during their college days. It is possible that those alumni who have joined this session, they may be from that batch. Therefore, if such is the situation, then you will have to prepare yourself thoroughly for this All India Bar Examination. Speaking for the entire country, more than 23 lakh students are advocates are there. Like Maharashtra, we are having 30,000 during this COVID. Likewise, in the entire country, more than 5 lakh students are there who have enrolled during this COVID period. As a result of that, you will appreciate that there is an immediate need for such other measures also for maintaining the professional standards. Now, there are around 1,500 law colleges at the most, we can say. Every year, there is an increase in the law schools. But despite that, an ultimate holistic approach is required to be taken for maintaining the standards of legal education. The standard of the legal education cannot be maintained by only Bar Council. It is a joint activity which is to be initiated by the teaching and non-teaching staff of the different colleges as well as the universities. Not only this, this is a joint activity of all those stakeholders like lawyers who have got license to practice. Ultimately, don't forget, this entire system is for that common man, that common litigant who is a consumer of justice. That common litigant is at the center and we are supporting that particular person. If that common litigant who is a consumer of justice fails, then we are there to help him. We are there to achieve his dreams. We are there to assist him in getting a justice. In doing all those things, most important is to maintain our standards, maintain our dignity, follow the ethics. All these things are required. Once we do that all, I'm sure the faith of a common man, which is there on this system, will strengthen day by day. I must tell you, while summing up, our profession, which empowers you to wear a black coat, is something like a blessing. This black coat is for that society. Black coat is for that common man. This black coat will give you in return something which is more than your expectation and the standard. I am a Maharashtrian person, so therefore allow me to use that Marathi phrase. आपल्या लायकीपेक्षा आणि अपेक्षेपेक्षा जास्त हा काळा कोट आपल्याला देणार आहे. Having said about this, let me tell you that there is only one expectation. Expectation is you will have to be loyal to this black coat so that you can get all those blessings which you will receive from this black coat. It's a time to wind up. All the best to all my young Indian legal brain. I'm sure very soon we will be meeting. Till that point, thank you everybody. Thank you management. Thank you in charge principal and the vice principal. All the best.
Thank you, sir. Good morning to one and all present here. I, Vice Principal Shobha Shevaye, on behalf of Seva Mandal Education Society, Smt.K G Shah Law School,